will help him a lot. So I will assume that he was doing that as a police officer, obviously, because he wanted to be the one maybe to crack that case. Then he wanted to know, what do I know about it, since Jerry was my friend.
And I think earlier I asked whether after that engagement you had any further interaction with him about this matter.
The kidnapping matter?
Yes.
No, he never, it was only that time.
Okay. Now, you recall that we were dealing with these issues because paragraph 2.2.3 and 2.2.4 had inquired of you the nature, extent, and frequency of communications and physical meetings with General Sibia. We had said this perhaps is about your third encounter with him. When next did you meet with him, and for what purpose?
The other encounter, I said, is the one that I do not want to talk about it because I'm being charged with corruption. I'm not talking about 204. I'm being charged with corruption, and then they also investigating him on that matter. So,
please say the last bit again. And also,
the investigators, they are also investigating him. Firstly, I'm describing the crime. So yes. I said I'm being charged with corruption.
Is this in the Pretoria case?
The Medicare, yes.
The Medicare case?
Yes.
Oh, this is corruption in the Medicare contract?
Yes.
Is it part of the ongoing criminal case, or would that be an extra charge?
Ongoing criminal case.
So you then, this corruption that you fear you may face a charge for arises from your physical meetings and gatherings and communication with General Sibia?
That is correct.
And would both of you be charged with corruption, or just you?
I'm already charged, so I'm saying I do not want to say things that
okay.
will end up making my trial difficult for me. Well, basically what I'm saying is it will infringe my fair trial rights.
Okay. So that will infringe your rights in the ongoing corruption charge in what we call the Medicare?
Yes.
Because corruption is one of the offenses you
yes.
are charged with.
Is this the IDEC investigation?
Yes, that's correct.
And this would relate to your interaction with General Sibia. You may disclose something, you say, that would compromise your defense against the corruption charge if you were to speak about this fourth interaction with General Sibia.
That's correct.
Okay. And thereafter, any other?
There's two occasions, but both is the same corruption charge, yes. I'm not mentioning when I went to see him in his office for the Jerebo issue and also for the public works hospital lease.
So, if I understand you correctly, after your engagement regarding the kidnapping of Mr. Bushoka, you met with General Sibia 3 more times.
Commissioner, I'm just saying, on top, I cannot guarantee that it's 2 or 3. I'm just saying from the top of my head, I'm not sure about that.
Oh, and where's my 3? You had said, I said, when was the next time you met? And then you brought up the corruption case in Medicare. And I say, beyond that interaction, any other, you say 2 other occasions. That's how I land on my 3.
No, I said except the 2 other occasions when we met in his office. 3 occasions, actually.
So now you had this interaction that could potentially undermine your defense in the ongoing corruption case. I want us to get past that interaction. I want the next time you met with him.
There is no next time.
Was that the last interaction you had with him?
Yes. The last
Or-
interaction is, I think, what is it, that engagement party? I don't think there was after that. I don't recall.
So the next time you met with him thereafter, to your recollection, was perhaps the engagement party you referenced earlier? You have to verbalize your answer.
Yes, I said that, Commissioner.
Don't nod, Mr. Madlanga.
I'm sorry.
Thank you.
The
No
recording
problem.
doesn't see a nod. And since the engagement party and the interaction at the engagement party, have you had any meetings, physical or otherwise, communications with General Sibia?
No, I've never.
When was this engagement party, to your recollection?
Sometime in 2024.
So you said, okay, you can use the season, winter, summer, I'm trying to,
I think it was towards the end of winter, if I'm not wrong.
so I can say mid-year 2024.
July, maybe July, somewhere
Okay.
there.
Did the other witnesses not say it was 14 September?
No, I'm not sure, Commissioner. I'm not saying that. I'm just.
There's confirmation that, yes, the
Yeah.
other witnesses so said.
He might be right. I'm not.
Okay.
I'm not saying that is the truth.
So then I'll accept that. The last engagement you had with, or interaction you had with him was at the engagement party in 2024, whatever the actual date was.
Not the last. The timelines, I'm a bit confused with them. But it's one of the interactions, yes.
Okay, then let's get past the engagement party. When did you next engage and interact? After, now we have the engagement party in our minds. I trust fund was heard by all, so after that, when did you next engage?
What I can remember is our own.
Sorry to do this.
Yes, Commissioner.
There's confusion about the third and fourth occasion. If the engagement party was in September
Yes.
and the raid was on the 6th of December, then it must mean the engagement party is the third occasion and the raid is the fourth occasion, because December comes after September.
Indeed. Do you understand?
No, I understand, yes.
Yes. Remember, we discussed the
Your
kidnapping of Mr. Bushoha,
Yes, yeah.
and you said it was after the raid.
Yes.
So the commissioners point out to us that the order of things is not right. The engagement must have come before your engagement with him regarding Mr. Bushoha, because that was only after the 6th of December.
Of course, yes, I agree.
So we should swap the dates around.
Yes.
You said yes.
Yes,
Oh, you're still thinking. I don't know.
I'm thinking.
I don't want to rush
remember.
you.
I'm trying
No,
to
no.
remember. I think, if I'm not wrong, I also met him in 2025. So I'm trying to remember while you're speaking. I'm sorry. So I mean, I was trying to get the exact date.
Then perhaps if we say, while we correct that you then met him next in 2025, perhaps if we discuss the circumstances of that meeting and what was discussed, that would help us sort out the order of things, hopefully. So what did you, in 2025 when you met, what was it about and where and how did it come about?
Commissioner, I'm saying I think I met him in 2025. I'm not certain, but judging by the timelines, because after the raid, I remember I didn't have, there was no way after the raid, first, I'll say maybe 15 days, there was no way that I could have seen him because I was busy with police and then I was busy with my meeting with, so it must be maybe January, I think.
Oh, okay, I think I get you now.
I'm trying to have a proper recollection, so.
And is that in relation to the discussion around the kidnapping of Mr. Bushoha? That's the one you're putting it around January 2025, am I understanding you correctly?
Yes.
Okay. So then, after the Mr. Bushoha discussion with him, when you would have met again?
I don't think I've met him again after.
Since?
Yes.
Have you ever communicated with him directly or via Sergeant Ngosi?
Communication, yeah, I think there was a communication via Sergeant Nkosi, yes.
Are you able to just highlight what the communications was about and who had initiated such communication? And if they are different, then you can enumerate each and talk about who had initiated and what each communication was about.
The communication was through, all the time, was through Sergeant Nkosi.
But at whose instance?
If I remember well, the communication was regarding after the raid, why did I tell the police that I know him? So, I think it should be in December. After the raid, maybe before January, I think there was a communication.
Okay.
I'm just confused. I'm not.
Okay.
I'm sorry. I'm not.
Are you now referring, remember there were 2 raids in December. There was a raid at your house
Yes.
where the police were looking for Mr. Bushoka. Then there was a raid at CAT VIP services where there was the issue with the key and the fact that it's not in the right safe and firearms were taken. Which raid are you referring to?
After the first raid, I think 10 days after the first raid, that's when 10 days after the first raid, that's when I made that High Court agent application. And in that High Court application, that's when I mentioned that I know General Sibia. So that's when I get a message from Sergeant Ngosi that why did I mention that I know him? Because it was in the media, I think. So that's why I'm saying I think in December there was some communication.
So after the 20th of December?
Yes, somewhere there, yes.
Thank you. So, do you recall having a discussion with General Sibia about an application that was necessary to launch for the return of the guns and I think jewelry you said had been seized during the raid of your house or office, one of them?
Yes, but that is part of the case that I'm attending in the Johannesburg High Court.
Medicare?
No, not Medicaid, the other one. In Johannesburg High Court.
The one concerning the conspiracy to commit murder, attempted murder, and
Yes.
lawful possession of a firearm and ammunition, money laundering.
Yes.
What relevance does General Sibia have?
There is a relevance because I have my defense. I need to establish how did I end up being arrested. So because in my phone records, they are relying that I'm part of me and General Sibia and Minister Mkhunu. We part of people who plan to dismantle this PKTT unit. So that is something that I'm going to argue in trial, that how did I end up getting arrested?
What is the crime in dismantling the PKTT?
The crime.
Well, you said, perhaps I misheard you, my apologies. You said there is an accusation that yourself, General Sibia, and Minister Mkhunu are what about the PKTT?
Commissioner, when they did my cell phone downloads, there was communication which I do not want to, because it's part of evidence in my criminal court in the Johannesburg matter. But there is those engagements and where also General Sibia has been involved there.
You said something about the PKTT. Can you say that again?
The dismantle, of the team.
Oh, yeah, okay.
Yes.
So that's why I say, what is the crime in disbanding the PKTT? What's your understanding
It's
arising from that case?
Not the crime, not the crime commission. I'm saying part of my defense. I'm going to establish in court how did I end up getting arrested. The only way for me to explain this to you now, I have to go deep, and which I do not want to do that, and now disclose my defense strategy.
No.
I do not want to do that.
I'm not inviting you to. I was talking about an application you initiated or instituted in December.
Yes.
For the return of your guns and jewelry, which had been seized during one of the raids.
Yes.
And I asked the question whether you had not engaged with General Sibia around that application for the return of your property. So your response then speaks to the criminal case of murder and attempted murder and the disbandment of PKTT. And I'm not sure I understand.
Because your question, what you're asking me now,
Yes.
is also part of evidence. What you just asked me now is part of evidence, which is in my cell phone downloads.
Isn't maybe isn't that perhaps, Mr. Matlala, the best way to proceed is the direct question that is asked is you had such an application before court where you went to court to seek a return of your firearms. That's what Ms. Silo has asked at this point. So it seems to me that your answer would be yes, I did, or no, I did not. And then we pass that, and let's hear what is the next question before you get to a point where you say, but that case has to do with the matter that I'm presently facing and the defense. So maybe take it step by step. At this point, all she asks is you had such an application where you went to court, you wanted a return of your guns and jewelry. And answering that question at this point does not require you to get into the detail of that application, and I don't know if she intends to ask you that further question, but at least as a starting point, your answer doesn't require you to speak about what was in that application.
Commissioner, I already conceded that yes, I've made that High Court application, but the next question was, did I ever discuss that with General Sibia? That was her question.
And your answer could be yes or no. And if she says, what did you discuss? It seems to me that at that point, you may well attempt to raise your defense, your privilege.
Commissioner, I don't think this is fair, because now I'm disclosing part of my defense strategy now. I don't think that is a fair move. I don't think so.
You are not, at least as I understand, you are not saying, I don't want to answer that question because it will incriminate me. You are saying, I don't want to answer the question because I don't want to disclose my defense strategy.
That's correct.
So it's the second one.
Yes, that's correct.
And Mr. Lowe will decide whether that's good enough for purposes of further discussion.
Well, I would think that, and perhaps it's a tad unfair to Mr. Matlala, because the answer really lies in Section 3, Sub 4 of the Act, which means he must invoke some legal privilege. And in regulation, I think 610, it tells you that the only basis to refuse to answer a question is if you establish a privilege contemplated in Section 3.4, which is a privilege as recognized in law, and fear to disclose your defense as not one such privilege. So if that is the only basis, then you do not bring yourself within the ambit of the protection, because that does not constitute privilege. and you will be compelled to answer. You are raising a wrong basis to refuse to answer. It's not an acceptable basis, as determined by the law, not by us around here.
Maybe, Commissioner, is because you are speaking to, I'm just a mere layman. I do not understand the law, and then I do not know which case law I should invoke in these things. I think maybe my legal counsel will help me with that. I do not know how to invoke which section for that.
I think that's fair. That's fair. So maybe to address myself to the commissioners and ask the commissioners to inquire from Advocate Missy whether she would like to engage with that point on your behalf.
Thank you.
Thank you.
Ms. Missy,
Should I answer?
what are your
May I answer
submissions,
rather?
your submissions in response?
Yes, Chairperson.
Does the privilege extend to not, or rather, a witness saying, I will not answer because I do not want to divulge or reveal my defense strategy?
Chairperson, at some point you raised the question as to what exactly is this charge that you are facing that speaks to that particular piece of evidence and defense that you would not like to disclose before the commission. One, because we were only briefed with regards to the proceedings before the commission, we're not fully aware as to what are the charges that he faces in that matter that speak particularly to that piece of evidence. For us to then say to Mr. Madlanga, we do understand you, and from this perspective here, you would be able to claim your right to the privilege in terms of Section 3.4. And so, Chairperson, the only thing that I could do at this moment is if the Commission could allow us a stand out so that we can consult with regards to this issue, bearing in mind that we're also in a back footing with regards to the charges that relate to that case before the Johannesburg High Court, I believe.
Just repeat the underlying facts that give rise to this issue so that when instructions are taken, they are taken in the context of the point from which you moved to,
Yes.
for us to get to where we are now.
The chair will recall that Mr. Madlanga and I were recounting the incidents he met with General Sibiya and they discussed, and the idea was to understand the content of such discussions on each incident. And I had posed a question to him whether he had met with General Sibiya regarding an application he instituted for the return of his firearms and jewelry, which he stated at the time had been seized during one of the seizure, one of the raid incidents, either at the home or subsequently at his office. And he confirms, yes, he did institute those proceedings. So the question was whether or not he met with General Sibiya and discussed that with him, to which then he claimed he invokes a privilege, not in the Medicare matter that we've been dealing with, but the other matter in Pretoria, I think, about conspiracy to commit murder, attempted murder, unlawful possession of a firearm and ammunition, as well as money laundering. So it is in the context of understanding the charges that he's facing there, I'm trying to appreciate what his engagements with General Sibiya regarding, I would term it the lawful return of his property, what bearing it would have on that case. And That's where I think we fail
Thank
to
you.
find one, or I fail to understand. Let me lay it on my doorstep.
Thank you, thank you. Yeah, maybe for a fuller background, during the raids, some of Mr. Matlala's companies' properties, and indeed even his personal items were allegedly with regard to the personal, and I think it's common cause with regard to the property belonging to the company were taken by the police during the raid. And the alleged relates to, I think, Mr. Matlala, in a court application in which he was seeking a mandamus, in terms of which he said his, amongst others, his Rolex watch, or was it a Cartier? Oh yeah, Cartier and Rolex watches, and maybe some other personal item had been taken by the police. So in terms of the mandamus, he wanted the court to direct that those items be returned. But if my memory is correct, I think in the end he either withdrew or did not pursue those applications any further. So that's the full context. And so Ms. Sillo is engaging Mr. Matlala on that. Sitting here, I have no idea how that has anything to do with Mr. Matlala's defense strategy. But in any event, there's the point that Ms. Sillo makes, which is what's Mr. Matlala's defense strategy got to do with the privilege he is claiming, which is the privilege against self-incrimination. So that's the full context. Would you still say you want to take instructions, or would you accept that there is no basis for asserting the privilege in this context? Or perhaps it's not even the privilege, it's some other animal, an animal that I will not answer the question because it discloses my defense strategy. But in any event, I just do not see how an application for the return of Mr. Matlala's personal items, I do not see how that relates to any possible defense to whatever charge he is facing in this regard. But in any event, there's the antecedent question. Can he refuse to answer the question on that basis in any event?
Chairperson, while Mr. Matlala was giving his submissions, there was a point at which it seems to me that he makes reference to the issue of a charge and or within the case that he's referring to. And I'm wondering to myself, without having full knowledge, is there a misunderstanding on his part that we would need to consult with him about so that we're able to correct him and give legal advice as to whether he's approaching it incorrectly? This is the manner in which you would have to make the application or claim the right to privilege. Because I do specifically recall him making reference to a charge that relates to the matter. And that's why I'm saying I don't know what the charges are. I don't know how it relates to this particular piece of evidence that, or rather the issue with regards to the application not proceeding, how those two interlink, because now suddenly, or rather later on, he makes reference to it being part of his defense strategy. And as he noted, because he's a lay person, he perhaps might not be viewing this correctly, but he actually knows what he's trying to say.
Is that a point he can raise as a matter of law anyway? That is, I will not answer that question because it discloses, or rather my response will disclose my defense strategy. Is that a legal basis for refusing to answer a question?
Chairperson, now that we have taken the instruction and we've decided to proceed based on where we are, having not heard the application or proceeded with the application at the point, I believe during our consultations and as part of the application, it called into question as to whether as a suspect or as an accused, does he have a right in terms of Section 35, and it would go towards the issue of a fair trial, which there's a confusion with regards to that. I'm just off the top of my head on his part. And that's why I deem it important before we proceed for him to answer it, can we get an opportunity to understand exactly what is this point that he's raising that has to do with the charge and the evidence, as well as the defense that he wants to raise in the trial, Chairperson. I do believe, as he noted, that he's a lay person and lacks a proper understanding how. It's also to avoid an instance where, again, it's just regarded as a blanket approach of, because I am going to use this as a defense in my trial, therefore I don't want to address it. I do believe it's important that we get the opportunity to get an understanding exactly from why is he referring to this, why did he mention the issue of a charge, how does this all interlink, and then we can give him proper advice that in terms of claiming privilege, you have to make reference to the specific charge, etc., before you...
I have bent over backwards and allowed you an adjournment each time you ask for one, but we will never finish Mr. Madlaga's testimony if at every turn we have to do this. We have to adjourn for you to take instructions, and I thought this is just a legal question, and sitting here I just do not see the connection whatsoever with regard to an application, a civil application for the return of Mr. Madlaga's goods, an application which he did not pursue. He either withdrew it or did not pursue it to finality, so it died a natural death. I just do not see, sitting here, unless we get clarity, I just do not see how that has anything to do with his defense. But as I said, the antecedent question is, can that even be raised as a basis for not answering the question?
My question to that would be no, given where we are in terms of the proceedings. However, I still stand by the fact that he very well, just on that particular point that he tried to explain or go further on with regards to the charges, he very well would be able to explain to us at least so that we can give him proper legal advice as to whether he can claim a right based on that or not. Because Chairperson, like he said, he's a lay person. He's probably trying to approach it from this angle, but in reality, this is exactly what he's meant to be claiming based on ABCD. I don't know what the facts are as much as I also don't know what the charge is that he was trying to make reference to. I think I'm grappling with the fact that he did try and address the issue that has to do with charges, and it relates to the defense that he wants to raise. I also don't understand to what extent it would affect his ability to raise the privilege to not self-incriminate. However, I do agree with you that he can't raise the issue of fair trial, i.e. with regards to disclosing his defense, Chairperson. And that's the reason why I've asked for a stand down, so that we can at least give him that legal advice so that he understands where we are right now.
Yeah, you see, the difficulty with that approach is that it would be a matter of relative ease for every and any witness to say, I will not answer that question because it discloses my defense strategy. In circumstances where, when you look at the facts, it does not immediately spring out, the circumstances do not spring out and tell you in and of themselves that this has something to do with a possible defense. Civil case, civil application, withdrawn, and apparently, at least from the evidence that we have had, on the basis that no Cartier or Rolex watches had actually been taken from Mr. Madlaga, how that should then lead to the disclosure of his defense in the criminal case, for the life of me, that escapes me altogether. So the short point I'm making is it would be a matter of relative ease for anybody to say, I will not talk about that. That discloses my defense. And if there is no cogent explanation, we cannot accept that. we simply cannot accept.
Sorry, Chairperson. I think maybe I can assist if you allow me.
Yes, please.
Because I have to agree with you. You are right with one thing when you say you don't understand how this civil matter has to do with my criminal matter. Even myself, I didn't see the necessity of why the state will bring that up. But as you're saying, anybody can come up here and say this will infringe my fair trial rights. So I think what is best that I can do to prove that this thing is part of my trial and then is part of the case that the prosecutor has been relying on. Maybe if I can bring maybe a copy that is signed by the investigating officer to show that indeed this is part of my case. Tomorrow morning, I have that document on me. I can bring it tomorrow morning.
I see that it's 2 minutes to 6. Perhaps we should adjourn at this stage, and then that should afford you sufficient time, Ms. Missy. And yeah.
Chairperson, before we do adjourn, I would like to understand the position with regards to the suggestion that Mr. Matlala has made, which is to provide...
Can you please
My
pull the mic or
apologies.
speak?
Yes, I would like to understand the position with regards to the suggestion that has been made by Mr. Matlala, which is that perhaps he ought to provide us with a copy, because as I stated, I haven't seen it as well. I don't know what these charges are. And so it's so difficult for me to answer you and address you with regards to that. And maybe he does have a good point to make there. So what is the position to that?
No, that's acceptable. That's acceptable. Yes, you may bring the document you want to bring, Mr. Matlala.
Thank you, Chairperson.
Yes.
And Chair, before we adjourn, perhaps then to facilitate our engagement, it might assist if we were provided with both the charge sheets and you call it the Pretoria matter, the attempted murder case, and the Medicare. I'm not asking for your dockets, I'm asking just for the charge sheet, because that would give us a sense of what the offenses Mr. Matlala is charged with.
I think I have my charge sheets. The charge sheets, I don't know, I will ask. It's fine, we'll make a plan.
Thank you.
Chairperson, because if I may, I believe Mr. Maluleke is the attorney on record in those matters.
Of course, yes, yeah.
And he's still on record here. Surely that would be relatively easy for us to provide same.
Thank you.
Thank you,
Thank
Chair.
you. Let's adjourn and resume at 9:30 tomorrow.
Get in.